Welcome back to In Plain Sight, a Trading Hub podcast. I'm very excited to be recording our first podcast here in Sydney, Australia. So as usual, I'm joined by my co-host, Shane Gannison. And this is also a big first for us. So we're joined by a guest, Johnny Gordon, who is a partner at Ashurst here in Sydney, Australia. If you've read any of his work on, financial services snapshots, you can see he's got a real commentary around different areas in the market. And I think we've found that you have a real knack for making complex regulatory issues a bit easier to understand. It's something that we regularly read and really have a good perspective on what's happening in financial markets. So very happy to have you here as our first guest on In Plain Sight. Also for our first episode here in Sydney, Australia. So thank you, Johnny, for joining us.
Thanks. Good to be here.
So just before we jump, I think we have a few different themes we want to go through and touch on. But before we kind of jump into those, I thought we'd start just with, kind of as a quick warm-up question.
Start off at 10.
Exactly.
Yeah.
So you obviously in your role, you're going to speak with a lot of different market participants, market operators, regulators, banks, brokers, run the whole gamut. Are there any topics that you see coming up regularly with them? What's kind of top of mind when you're having these discussions with other people who are in the industry?
Yeah, I mean, it's a pretty broad practice, financial regulation, obviously. But there's one at the moment which seems to be pretty topical. I think it's getting a bit of airplay in the press as well around prediction markets and how that's going to be regulated around the world. Obviously, the US is leading the charge with CFTC regulation, but still playing out here in Australia. And that's a fascinating area because it's a bit of uncharted territory, I think, that intersection between financial regulation and gambling regulation. So we'll see how that plays out. But I find that pretty interesting.
Yeah, I think so. I should mention too, we're in Australia because we had our Sydney Reg Hub Summit just yesterday. I think prediction markets actually was something that you brought up in your panel. Shane.
I did, yeah. So I brought it up actually. Someone was asking me a question about digital assets. And rather than answer that question, I started talking about prediction markets because I think when it comes to, it's interesting your comment about the US leading the charge. So I think that's absolutely correct. But just the regulatory obligation of having to make sure that the underlying event is run efficiently so that you can have a financial contract over it, it's a huge mess, I think. I mean, how do you take on that burden? So I think, we're very, in Australia, what are you seeing? Is it, are people setting up this market here? Or are they trading through other jurisdictions?
Well, it's a bit of a grey area in Australia. Like a lot of things are a bit of a grey area in Australia as they are elsewhere. I mean, we're seeing interest from the offshore operators, so the platforms, as well as market makers who want to participate in that market or in those markets professionally. But there's still some grey to work through because the question will be, as in many jurisdictions, the extent to which those contracts could properly be considered to be derivatives, which fall within our financial regulation remit. But if they're not derivatives, then what are they? Would they be considered, for example, to be gambling contracts?
Yes. Yeah.
And then subject to, as in the US, subject to state-based gaming regulation. So that still has to be worked through, and there's a bit of flexibility in our regulatory regime to deal with that.
Okay.
But it's still pretty early days. And I think front and center for the regulators will be two things. One is the consumer harm risk. So being able to demonstrate how that is managed. And secondly is the capacity, as you've alluded to properly manage the underlying instrument, for want of a better word, or the underlying event, and the risk of, manipulation, insider dealing. We're seeing that playing out in the States. And that'll be front of mind for the regulators as to how they would manage that if we get there at all.
So you've seen some. I was reading some pretty shocking headlines of profits made on Polymarket, for example, in the hours before kind of military action in different parts of the world, and it just seems like a bit of a quagmire. But you're mentioning about whether something's a financial contract or gambling. I mean, the way, and I'm not in any way a legal expert, but the way I think about it would be if it's bilateral and the contract can't be then sold on to someone else, then it's kind of gambling. But if you have the ability to offset that via some third party on some kind of exchange platform, does that make it more or less? Is that how people think about it?
I think it's how some people think about it. It is actually, it will be difficult to work through. The way our law works is it doesn't work as simply as that. So if we've got a bilateral, if we've got matching buyers and sellers, then that's treated differently. So I think there's still some work to do, and there are differing views.
No, of course,
in the market as to how they should be regulated. But either way, we've seen in Australia ASIC, take action sort of 18 months ago with respect to binary options in the OTC CFD market. And that would likely be the mechanism that they'd look to in some way regulate these contracts, even if they can be characterised as financial products. So there's a long way to go, I think, in terms of where we end up.
If nothing else, it's really broadened the definition around insider trading, because at least in the United States, because they are seen as financial contracts. So somebody having, a friend who plays in Major League Baseball and saying, oh, make sure that, the first pitch is a ball or something like that. That's now being looked at as insider trading because they had that inside knowledge related to that financial contract. And we had a meeting with the CFTC and kind of, especially their surveillance team. And we're kind of asking them, well, now Kalshi, Polymarket, all these prediction markets where you can sensibly make financial contracts or which are, gambling on sports. Is that now part of your remit? And they're like, yeah, absolutely. So
I saw the CFTC signed a memorandum of understanding with Major League Baseball like last week.
Yeah.
Which and when that hit my inbox, I was like, sorry, have I read that MLB is in baseball? And I was surprised.
Yeah. No, I think it's really kind of shifted the ground for, the regulators and also like the surveillance teams, enforcement teams that are now at the CFTC, especially in terms of their remit and areas that they have to cover, which I think we're kind of completely outside of the normal jurisdiction of where they looked at before.
Yeah. Well, there's two things. One is on the insider dealing risk. The way our law is characterised in Australia is if it's information which is not generally available that would impact the value or price of the instrument. If it were generally available, that's the relevant test. So insider dealing law can apply to any derivative, including prediction markets if they qualify as derivatives. Second one is our obligation here in Australia, if you're an operator of a market that brings together counterparties, so buyers and sellers, then if you require a license to do that, it's an exchange-like license. It's called a market license, and your primary obligation is to operate the market in a fair, orderly and transparent way. So coupled with that obligation comes a need to have some capability to be able to monitor what is happening in the underlying, or at least access to the information. So, it'll be really interesting because it's obviously captured the imagination, and I see we've now got prediction market bars being set up for I saw that in the Sydney Morning Herald yesterday.
So bars is in like to have a drink.
I think the primary purpose is to play on the prediction market rather than have a drink. Yeah. But they're called prediction market.
So I saw something similar in the US about, there's this phrase about monitoring the situation, and that these bars where everyone's going to monitor the situation together, and then you can place these. Yeah.
I should start by saying that was a story about the US, not about. I haven't seen them here. I tend to go to the other type of bar with the drinks. That is. Yeah.
Well, I think that was our intended kind of our opener, but I think it's kind of
we took a bit of a segue.
Evolved into our so obviously something that was very much top of mind for us too. But I think one of the areas we want to discuss and really get your view on is the evolution of kind of markets, supervision, especially enforcement, specifically here in Australia. So we pay very close attention to any sort of regulatory actions, especially enforcement actions as they're coming out as a, surveillance vendor. How do we model this type of behavior? How do we understand it? How do we review it? But it does feel like the enforcement landscape in Australia is, shifted a bit. There's been quite a few interesting cases to come out of ASIC recently. I'd say, somewhat, not novel, but not necessarily fitting the mold of a lot of the other enforcements we've kind of seen previously, getting into commodity markets, touching on to government bonds and other areas. It'd be good to get your view. Do you think there is kind of a shift in enforcement and regulatory expectations from ASIC based on what they're putting out as their enforcement results?
Yeah, I don't think it's a shift. I see it as more of an evolution over time. I mean, our regulators, every year, ASIC, as part of their enforcement priorities for the following year, will always have market manipulation, market misconduct, insider dealing on the list, as would any credible regulator.
Yep.
So it's always been on the list. We've also we set up under our law. Market misconduct can be prosecuted as criminal offences and can be prosecuted as civil penalty provisions. So if it's a criminal prosecution, like all criminal standards, it's proven beyond reasonable doubt. If it's civil penalty, it's on the balance of probabilities. And what we're seeing in more recent times is we've had a couple of cases that ASIC has brought to the court seeking civil penalties with respect to alleged manipulative conduct. But that hasn't been their primary course of action over the last decade. Their primary course of action has actually been to focus on the gatekeeper rather than the underlying traders. And there's a different mechanism through which alleged manipulation is dealt with, and that's under what we call our market integrity rules, which are rules made by ASIC that govern stockbrokers, futures brokers. And the reason that's important is because the decisions that are made, and there have been for over the last 20 years, there have been dozens of matters that have been dealt with under those rules or their predecessor rules. They used to be ASX's rules. But those matters are not heard by a court. They're heard by the Market Disciplinary Panel, which is a panel of peers. So it's a hangover from the old mutual exchange days. You've got industry peers bringing judgment on brokers who have allowed or through whose activities have allowed or alleged manipulation to have occurred, and it's a different standard. So firstly, it's still on the balance of probability, so more likely than not, but the obligation that is on the broker in that scenario is to not place orders where a reasonable market participant in their circumstances ought to have suspected manipulative trading. It's a very different test to proving intent. And so what we've seen, and it's really this is an interesting development, is we've had a number of cases go before the Market Disciplinary Panel in 2024, 2025. In two of those cases, unlike predecessors, ASIC has taken separate court civil penalty proceedings against the underlying clients. And that is a new development. So firstly, they've gone for the gatekeeper through the Market Disciplinary Panel process. And then secondly, they've also gone after the underlying trader who's behind that trading. That's a relatively new development, not without precedent, but it's particularly a new development in the energy and wheat futures markets here.
It does feel so. I think so. We from our non-Australian home locations have been reading these cases with interest, actually, because I think we have not seen similar gatekeeper enforcements in the US, in the UK. We more oftentimes will see these underlying type enforcement to the other direct client. But I was quite struck. I mean, I was reading some of these filings with our Australian lead here at Trading Hub, Bron, and I was struck by the gatekeeper obligations. First of all, this your comment about reasonably having reason to suspect that these were suspicious. I mean, some of these cases now in the public domain, months going by without kind of addressing things. I think that putting that aside for one second, but the underlying clients who are perhaps not aware that what they are doing is manipulative. I was reading again in the public domain reference to the fact that kind of at board level there was a signed off strategy that in order to reduce the price of buying 1 megawatt hour or whatever it was from Shell, that this is what we'll do. And so is there an education problem that needs to be addressed as well?
Yeah, I'm not sure if I'd necessarily characterize it as an education problem, in the sense that you can break a law without being aware of it.
It's no excuse.
But obviously education would help. But equally, that particular matter that you're referring to, that particular trader is being prosecuted for manipulation activity, and therefore ASIC needs to demonstrate essentially that the trading was artificial in the sense that it didn't reflect the forces of genuine supply and demand. And what comes with that is looking at what the intention.
Yeah, so a higher burden.
An intention. Yeah. Well, it's still a balance of probability.
Oh, it's still a balance.
It's still a high test to prove intent. To prove intent or to prove that there wasn't a genuine intent to trade. But that. But the language that was used in that particular communication is what everyone is focused on.
Yes.
And does that therefore suggest that in fact there was an intention to achieve an outcome that might not otherwise have been achieved with genuine forces of supply and demand? They're really complex questions, as we all know, and ultimately that'll come down to expert evidence. One thing just to reflect on for the gatekeeper matters, so where the market participants have had action taken against them, they're actually not decisions of ASIC. They're decisions of the panel.
Okay.
So the decisions of the panel of peers. The matters are initiated by ASIC, and ASIC puts forward its case. The participant puts forward their case, and commonly those matters are resolved away from a formal hearing of a panel. So in any of those types of matters, you don't necessarily get clear guidance as to what's right or wrong. You're not getting that same, perhaps, legal intellectual
rigor, the legal clarity
that you might get through a court.
That you might then people can rely on later on because you've had case law essentially.
Yeah.
Interesting.
And I mean, I guess if a bank, broker, pretty much any market operator starts receiving, some notices from the regulator or an exchange around kind of questioning this activity and reviewing it, I think pretty much their first call is to a law firm and kind of say, can you help us here? What are we going to need to do in terms of, potentially defense, but also remediation, kind of making sure we're kind of not having this problem again. You don't want to have, especially any sort of recidivism is always kind of going to end up in a much higher fine. I mean, how do you kind of see that from banks in terms of kind of getting out of that cycle? Because you do see firms that kind of get in trouble a few different times and kind of going through the process before they kind of get it right. Is there something that kind of distinguishes those that kind of, all right, here's how we act and remediate, get through the problem versus the ones that kind of get stuck in a bit of a cycle of having to remediate issues or having more issues compounding on each other?
Yeah, I think there's a lot of factors at play in there. One is the extent to which the banks or participants are resourced up for surveillance, and some are materially bigger and more sophisticated than others. Some participants also might perhaps take an overly generic view of what is appropriate or inappropriate. So whereas Australia has some quite specific market circumstances that are relevant to that gatekeeper role and understanding whether there would be a suspicion of manipulative trading. So different level of resourcing, different level of sophistication, and also it's incredibly hard. Right. And it's, the expectation of the regulator is that you're all over it and that you've got your systems and alerts and controls in place. But sometimes it does, if what is being looked at is a pattern of trading, then sometimes that does take time to evolve and time to detect, even for the more sophisticated players. So those who do it well are well resourced, have good governance around it, keep up to date with what's happening in the relevant jurisdiction, and take a sophisticated approach. Those who don't do it as well are the ones that don't do those things and necessarily have to be more reactive to getting a call or a notice from ASIC.
Yeah. I think one of the other themes, we can kind of slightly pivot, that we wanted to talk about was technology. And again, this is something that came up yesterday in our event. We had a regulatory panel, and I think one of the themes that kind of came up there was the pace at which even regulators are having to move at, because of the pace at which banks are moving at now is so rapidly increasing. And I think a lot of that too is obviously driven by innovations in artificial intelligence and how that's really helping to facilitate development of software, whether that's be compliance, risk, or even on the trading side of things. But it does feel like there's a big shift from the regulators too, in terms of looking at that, understanding it, and understanding that that is something that's going to be used by market participants. Whereas, I don't know, probably 5 years or maybe even less ago, if you had spoken to a regulator about, we're thinking about implementing some sort of AI in anywhere across the bank, you get a very skeptical view, I think, from them around how you're using that versus now, ASIC's putting out reports around using AI within financial markets and giving some standards around governance and how to kind of operate it safely. So it does feel like there's a big shift there. I guess, what are you seeing there? Is that something that's kind of coming up in your discussions around willingness to use AI, adopting it, and how we can do that safely under the regulatory requirements?
Yeah, I probably can't add too much in terms of detail, but other than to say it's inevitable, I think it's still taking, I'm not sure it's at a level yet where people would have sufficient confidence to be able to rely on it solely. And in any event, the expectation is going to be there will need to be obviously appropriate governance over it and some level of a significant level still of human interaction. But I think it's inevitable, all right? So firstly, it's inevitable that we're going to have AI generating orders to start with and generating trading strategies. We're going to need AI to be able to monitor what AI is doing from a surveillance perspective.
Yep.
And the capacity for humans to do that without AI, I think, is pretty constrained. I think the capacity for humans now to meet the expectations that are set of the gatekeepers is pretty constrained.
Yeah.
The ability to review multiple alerts and put facts together, many of which you won't know because you won't necessarily know all of the client's underlying positions or trading strategies.
Yeah.
For a human to keep up is pretty hard now. I can only imagine that will get significantly harder as we get into AI-generated trading activity.
No, I think you're absolutely right. And I mean, in the medium term and even in the long term, you should never bet against technology. So I think this is, you're right. It's inevitable. It's going to happen. I think the way I look at it is it's a productivity revolution, right? It's like the horse and cart and the steam engine. The AI is going to create winners and losers in every industry, and I think trying to balance kind of adoption, the pace of adoption, but also the pace of making sure the governance that, people are going to trip up on that as well. And I think it is easy perhaps to tie yourself in a knot. If you move too quick, if you move too slow, it's like this tightrope walk. But I think you're right. And an AI making trading decisions or some kind of, LLM or whatever, spitting out strategies, I don't think it'll be hard for an LLM to learn that a good way to make money would be by spoofing, for example. And that's not impossible.
Yep.
So having the right guardrails in place is, I think, critical. But your point about, in our industry, the software industry, I mean, it's just been completely democratized, right? This kind of the ability to go from idea to execution, what might have taken 6 months can now take 6 hours. So your point about, gatekeeper obligations being, it's hard to deal with now. I think, hopefully we see a trend towards better and more rigorous control if we're able to deploy this technology responsibly.
Yeah. And that's looking at it from the position of the gatekeepers. The end clients will in many cases not be regulated at all.
Yeah.
Right. So, and they will be utilizing the technology. So, I think it's inevitable that people will need to invest, and the expectation will be that they invest alongside the expectation that there's appropriate governance around that, and the human experience, the human understanding, at least for now.
Yeah.
At least for now is still a critical part of any decent surveillance program.
So from this is just maybe I'm going off piece a little bit here, but as from a legal perspective in Australia, where does the responsibility lie if a human is placing an order versus if an AI is placing an order? Is there a responsible individual that's always has to be behind? How does that work here?
No, I mean, we have algorithms generating trading now, so it's not. There's no need for there to be a human making a
But
decision.
the institution is, of course, always
the institution is always on the hook. The next level from that is the accountable persons. So, for example, if you're a regulated bank or regulated insurer, then you're subject to an accountability regime in Australia, which makes individuals accountable.
Similar to the UK.
And the institution accountable for having appropriate mapping of accountabilities across the organisation. That's not a feature of the regulation of our securities dealers and derivatives traders. If you're a bank, yes, it is. But if you're not a bank, then that accountability regime doesn't exist in Australia, unlike in the UK, for example, where it covers all regulated entities. So the question, there was always an expectation, and it was made clear at the time that our government would introduce the regulation for accountability in the prudentially regulated entities, the banks, the insurers. But the comment was made at the time that we will see where that takes us, and there may be a case for extending that to other regulated institutions going forward. So we'll see. It's still pretty early days in Australia for the banking accountability, financial accountability regime. We'll see how that extends. Having said all of that, when ASIC investigates a regulatory failure, whether it's failure in a gatekeeper role or any other regulatory obligation, it's pretty common these days for the statutory notices to ask who is responsible, who is accountable. Tell us your governance processes. We want to see all of your policies and procedures and who is responsible. So they'll hone in on individuals, but not necessarily with a view to taking action against those individuals, but wanting to understand how the failures occurred.
It's an interesting point too, because I think with most kind of tech innovation within financial markets, so it's really kind of driven by the front office and the people who are kind of producing returns. So they can say, okay, well, we can use AI potentially for creating, orders and coming up with strategy that's going to make money. Then they're going to use that. And then it's kind of the burden becomes on everyone else to kind of keep pace with that. Like, as you said, in terms of, okay, well, then how are we going to monitor this, like internally within the bank, but then also from a regulatory perspective, it's really kind of keeping in touch with the people who are kind of really driving the capital creation, really.
Yes, and it's just happening faster. I mean, that's the evolution of it. I mean, before, if we go back, 30 years and you're on a trading floor, I'm sure the back office had no idea what the front office was doing in that scenario. They wouldn't find out until 4:30 in the afternoon when the papers came back. But I think it's just a natural evolution now. It's all happening faster and faster, and there will be an expectation that back office keeps up.
Yeah. Well, I think we've already kind of seen that to some extent too. Now more, so like you have a lot of algorithmic trading going on. Now I think becomes almost somewhat the in automated trading, the expectation of regulators that even surveillance teams have some sort of automated reviews, looking to incorporate algorithms to understand the trading activity, because if that's kind of what they're using, the technology they're using to trade, you kind of need to be using similar technology to supervise the markets. So. And
you've got to use it in two respects. You've got to use it in the real time or the near real time, but also the expectation that you're also looking backwards at what might have transpired over a
longer horizon.
And that's frankly what regulators do, right? Every time you're the subject of an investigation or market disciplinary panel proceedings or court proceedings, it's always with the benefit of hindsight. So the relevant test, for example, for the gatekeeper is, would a reasonable market participant have suspected this trading? It's not what you suspected or even what you should have reasonably suspected. It's what a market participant acting reasonably would have suspected. So it's all very easy in some respects to look back and see a failure and say, well, how come you didn't pick that up?
So, hindsight is 20/20, isn't it? That's the thing.
Shifting slightly, but kind of staying in the technology space and when we're towards, blockchain technology, digital assets, I think there's been quite a lot of movement in this space, especially in Australia. ASIC is classifying more, more the space in terms of actually allowing them to be traded as financial products. How do you see that shift? Do you think potentially more banks and larger financial institutions are going to get involved in this space, or are you seeing them already getting involved in this space?
Oh, definitely the latter. Again, I think that's inevitable. Yeah. That's where we're headed. I don't think you can really avoid it. The way it's cut at the moment is our law reform, which is proposed at the moment, isn't really seeking to expand the universe of financial products. It's capturing the platform as a financial product. But whatever it is that you're trading on that platform may or may not be a financial product. So they're not necessarily expanding the remit of what would be regulated financial products. They're going to regulate the platform, but not necessarily the product. But we've done a lot of work in this space, and everyone is thinking about how can we tokenize, how can we build a distributed ledger model for what we're trying to do. And we had a great experience over the last few years working with FCX, setting up their securities market, which is a fully tokenized market. And that's just, again, it's inevitable that's where the world's headed.
Yeah, it does, especially with some of the different stable coins and other products where it does, from a market operator perspective, if market participant, if that is another product that you can use as a hedge against another product that's going to essentially operate the same way, and especially for interest rate, trader, it does seem kind of like, well, I'm not going to be able to do my job as well if I don't have access to that pool of liquidity. And so it's kind of, like you said, it becomes more inevitable the net that comes in. And then I think from us almost then creates some other issues around, I think good understanding around kind of cross-product manipulation or cross-product surveillance, even really understanding the universe of what your traders are trading. Now that may not just be kind of constricted to, listed markets, OTC, but now digital assets could potentially tie into that pool of areas that you need to understand holistically to understand what they're doing.
Yeah, I mean, the world used to be simple when it was only exchange-traded options over equities, both of which were fully regulated markets. But then if we look at futures markets, you've got obviously a raft of underlying commodities and fixed income instruments under futures, so you've got to understand those. So again, it's an evolution, but I think we're asking a lot for people to understand as that universe of other underlyings or related instruments
grows and grows. Yeah. So, Jenny, I think one of the things, Andrew and I spent a lot of time in the US, and, we've seen the changing of the guard at some of the US regulatory agencies. And oftentimes, I'm kind of putting it lightly, a changing of the guard at some of the US agencies can mean a kind of complete 180 in the philosophy, an enforcement trajectory and kind of supervision trajectory of that agency. I think ASIC recently have had changing of the guard at the chairman level. Do you anticipate any significant changes in ASIC's philosophy?
Short answer, no. I think it's business as usual at ASIC. Sarah Court, the new chair, has been preparing for this role for a while. Okay. She's been leading the enforcement charge at ASIC. They've made it very clear that it's a continuity in terms of how they're looking at their role. So they'll continue to be very strong and looking for messages that they want to give to the market. And I think it'll be business as usual.
Great. I think that's a great point to end on, really. So nothing else. I just want to thank you, Johnny, for joining us, for being our first guest on the podcast. Also, it was great being able to do this podcast here in Sydney, Australia. And thanks to all of our guests who came to the Reg Hub Summit yesterday. We always really love coming to Australia. And it's sort of great to see what community there is within the financial markets, surveillance, compliance people. They're always really eager to engage and understand, how things are changing across different regions and here locally. So it's always really insightful discussions when we come here. And with that, let's say thank you to everyone. And please tune in for our next episode of In Plain Sight.
Thank you very much.
Thanks very much.
Thank you.
Thank you.